Hi everyone, welcome and thank you for joining this Ciarb webinar 2025 in Focus, Charting the Course for 2026. My name is Aruna De Silva. I'm a Senior Dispute Resolution Advisor here at Ciarb in London. This webinar is the second part of a two-part series where we explore major developments in ADR over the past year and look at what lies ahead for 2026. In today's webinar, we will discuss how global economic and political shifts in key regions have impacted the ADR landscape and explore the emerging ADR trends and innovations shaping 2026. The regional focus of today's webinar will be on Europe and the Americas. Before we get things underway, I would like to turn to several housekeeping matters. This webinar is being recorded, and the recording will be shared with the participants after the session. We encourage interaction from our participants. If you have a question for the panel, please leave it in the Q&A box found at the bottom of your screen or in the chat box. You can also use the chat box for general discussion and any technical problems, but please be aware that other attendees may be able to see your comments. Our logistical team is here in the background to help in case you have any issues. We have an excellent lineup of speakers joining us for today's webinar. I'd like to now ask our speakers to introduce themselves. Looking at my screen, Anne, could I ask you to go first, please?
Yes, be happy to do so. I'm Ann Ryan Robertson. I'm an independent arbitrator located in Houston, Texas, and it was my great pleasure to be the 2021 president of the Chartered Institute of Arbitrators.
Thank you, Anne. Patricia?
Hello, everybody. I'm Patricia Sangalli from Milan, from Italy, and I'm here representing the European branch of the Chartered Institute of Arbitrators as PR officer, and it is a great pleasure to be here today with these distinguished colleagues. Thank you.
Thank you very much, Patricia. Anna, can I ask you to go next, please?
Hello, thank you so much for the invitation. My name is Ana Jaimes, and well, I have over 15 years of experience acting as counsel and arbitrator in investment and commercial disputes.
Thank you, Anna. Last but not least, Bernard. You're on mute, Bernard.
I think it's okay now. My name is Bernard Potti. I'm a partner at Batista Martins Advogados in Rio de Janeiro, Brazil, a director of education for the Ciarb Brazil branch, and it's an honor to be here with all my distinguished colleagues. Thank you.
Thanks so much, and huge thanks once again to all our speakers for joining today's discussion. So this webinar is organized into two parts. In part one, speakers will provide an update and overview on ADR developments from their respective regions to help frame today's discussion. To be followed by a Q&A roundtable style discussion thereafter. So diving right into part one, we are going to go to each of the speakers to get sort of an overview and update about what's happening in their regions in ADR. Could we ask Patricia to share what's going on in Europe, please?
Yes, thank you, Aruna. And first of all, I would like to give just a brief view of what is the European branch of the Chartered Institute of Arbitrators in Europe. We are working very hard to develop arbitration and ADR. We have a committee with our distinguished colleagues, and we have chapters, and I would like to mention some of them, like the Baltic states, the Benelux, France, Germany, Greece, Italy, Iberian Peninsula, and Russia. And we are working also now to have a new chapter in Romania. So with this first overview of the European branch, I would like to give you also some of the trends that we have for international arbitration and an ADR in 2025, focusing on the global trends. And the perspective is given from the Queen Mary University of London survey, the 14th survey of the Queen Mary University of London. We have a changing landscape in international dispute resolution. The survey confirms what many practitioners already perceive in practice. So international dispute resolution is no longer centered on a single tool, but on an increasingly integrated ecosystem. And this is now more frequently combined with alternative dispute resolution mechanism. So this evolution reflects a broader shift in mindset. Parties are no longer asking which mechanism is best in the abstract, but rather how different mechanisms can work together to resolve disputes more efficiently, economically, and flexibly. So one of the most striking findings of the survey of 2025 is the clear preference for a combined approach. 48% of respondents now prefer international arbitration together with ADR, while 39% still favor standalone arbitration. And this is particularly significant because it represents a reversal of the 2021 trend when standalone arbitration was clearly dominant. And over the past decade, therefore, we see a steady movement towards integration rather than substitution. So ADR is not replacing arbitration, but complementing it. And at the European level, mediation has been clearly defined by the Court of Justice of the European Union as a structured process whereby two or more parties attempt on a voluntary basis to reach an agreement on the settlement of a dispute with the assistance of a mediator. So in case, for instance, of Italian case law further clarifies a key point. What truly distinguishes mediation from the ADR tools is the central role of a neutral and impartial third party whose function is not to decide but to assist the parties in reaching a solution. And this is, despite the global trend towards integration, the survey reveals a distinct European feature. European practitioners show a stronger preference for standalone arbitration, 51%, favoring it compared, for example, to Asia Pacific region, 37%. Then we will see with our colleagues the situation in the other countries. And another interesting thing is at a EU level, the directive of 2008-52 EC, which explicitly aims to facilitate access to ADR and to promote amicable dispute settlement. So to give a short conclusion to that, the Court of Justice of the European Union has clarified that this directive mentioned does not prevent member states from making mediation mandatory as a condition for bringing legal proceedings as long as access to justice is not ultimately denied. So this is very important. And then we will see, of course, the efficiency as the key driver and the role of the seat of arbitration in some cases. But I will give the floor to my distinguished colleagues right now. Thank you.
Thank you, Patricia. It's very interesting to hear the growth of ADR and the holistic approach that's been taken in Europe. And I think other speakers will also have some sort of insights into how other ADR mechanisms are playing a role in addition to arbitration. So let's move on now across continents, and let's move on to North America and see what developments have been occurring there. And could you provide us with an update, please?
Or I'll be happy to do so. And I want to thank you for the opportunity to participate in this webinar. And my focus is going to be primarily, not surprisingly, on the United States of America. I'd first like to address something that Patricia raised, and that was the issue of mediation. The United States has had a very robust mediation practice for many years. I'm in Texas. Texas has had a mediation statute since 1988 that protects mediators from suits and imposes confidentiality. Many of the other states in the United States have similar statutes. It is not unusual for parties to want to go to mediation, even in the arbitration arena. And in fact, the AAA rules envision that the parties will go to mediation alongside their arbitration. Turning now to some of the developments, I'd like to talk very briefly about two cases that have been recently decided, and then I'd like to couple that with some very exciting rules, new rules that have been designed and implemented by the American Arbitration Association. So the first case involves the intra-EU enforcement of awards rendered under the Energy Charter Treaty. As you know, they are not enforceable in the EU, but the question is, are they enforceable elsewhere? And the US courts have taken the position that Energy Charter awards are in fact enforceable in the United States. However, there is now a new wrinkle. In late 2025 emerged the case of Mercuria, and Mercuria had proceeded under the arbitration rules of the Stockholm Chamber of Commerce with a Swedish seat. The Swedish seat allowed Poland to seek to set aside the award in the Swedish courts. And the Swedish court, sitting as an EU member state, annulled the award. The investors then sought enforcement in Washington, D.C. At the D.C. District Court, Poland filed a motion to dismiss. The courts held that they had jurisdiction under the Federal Sovereign Immunities Act, so it satisfied the arbitration exception threshold because at issue was an annulled award. But the court ultimately refused to enforce the award under the New York Convention. And the court explained that the U.S. courts ordinarily will not enforce an award lawfully set aside at the seat, absent a judgment that is repugnant to the fundamental notions of what is decent and just in the U.S. And the court there emphasized comity, instead simply put, comity is at its zenith here because the issues are of the utmost importance to the EU and of minor significance to the United States. In short, the court declined to second guess the EU courts and granted Poland's motion to dismiss. This will have far-reaching implications for those who seek to enforce enforce Energy Charter awards in the United States. The other case is one that involved Baker Hughes and the DIFC-LCIA, which, as you know, was dissolved. And there was a robust fight about whether or not there should be arbitration in Dubai due to the fact that the DIFC-LCIA had been dissolved. And the court there held that, yes, the parties would have to arbitrate at the Dubai International Arbitration Center, even though the DIFC-LCIA had been dissolved. So that was a very interesting case that came out of the US. But now, if you'll allow me, and I'm going to spend a little bit of time on this because it is pretty groundbreaking, I want to talk about something that has both domestic and international implications, and that is the American Arbitration Association's new set of rules, which are referred to as the AI-led rules. Now, this year, the AAA celebrates its 100th year, and it is the largest arbitral institution, they say, in the world. Obviously, they do a lot of different types of arbitration, both domestic and then through its international arm. of the International Center for Dispute Resolution. And it prides itself on being an innovator. Almost every set of rules now has an emergency arbitrator provision. The ICDR was the first in 2006 to implement an emergency arbitrator provision. So, what are these IA-led rules? Well, they're very narrow in their application. They are an opt-in set of rules for two-party, document-only construction disputes administered by the AAA or the ICDR. Parties must affirmatively choose these rules, otherwise the case proceeds under traditional procedures. What occurs is that it uses a structured prompts and conversational AI to produce a draft response to award to the party submission. So you're using AI, documents only, to get a draft award. Then every case is overseen by a human arbitrator who reviews, edits, challenges, and ultimately signs and issues the final award. The human remains responsible for the decision and its reasoning. It is considered to be a time and cost saver for a specific subset of construction arbitrations. They estimate that the time savings is going to be between 20 and 25%, and the cost reductions would start at 35% if you utilize it in the documents-only construction disputes with two parties. This in turn takes care of one of the issues that you hear parties complain about all the time, which is length of time and cost. It's important to remember that it's not unsupervised or an autonomous decision maker. It does have that human element. In fact, it was developed utilizing excellent construction arbitrators who gave advice on how it should occur. But it is a tool that's tailored to repeatable patterns and record-based nature of documents-only construction disputes. And so with this, we're seeing the idea that AI can, in fact, augment the decision-making of humans in international arbitration or domestic arbitration. And that is one of the biggest new developments in the rules.
Thank you, and thanks so much for that sort of very, very useful update. And no doubt some of those cases, as well as the AI arbitrator rules, will have sort of far-reaching impact and influence across borders and in other regions as well. Now I'd like to turn to sort of an update from Latin America. Bernard, can you let us know what's going on there?
Of course, Aruna. Just a quick caveat at the beginning. I'll speak mostly about Brazil, but I do have some updates from other countries from Latin America. And following the structure led by Patricia and Anne, I would like first comment on the use also for mediation here in Brazil. 2025 saw our mediation statute complete 10 years. The Brazilian mediation statute is from 2015. And we have seen year after year an increase on the use of mediation. The most up-to-date data shows that we did have an increase for the last 3 years of 30% year over year, and 3 times increase also on the amounts in dispute involved in mediation here, particularly as Anne also commented, in mediation that occur during arbitration. Where arbitration stops to leave a window for mediation. I would also like to comment very briefly on some updates regarding the Ciarb Brazil branch, which we together with its Peru chapter. In 2025, we have completed a 2-year project to study and develop a guide aimed at the Brazilian practice on the use of written statements for fact witness, and are currently organizing some events to showcase this guide. The next one will be in Miami. If anyone is interested, it will be on the 2nd of March in Miami, together with the AAA and the University of Miami. We also had our annual Williams-Vismuth commercial arbitration problem analysis. We had one in 2025. Now, just a few days ago, we also had held one with 2 seminars discussing the issues argued in the Williams-Vismuth. Had a number of events across the globe, from Paris, Lisbon, São Paulo, Rio de Janeiro, and Peru, and are now beginning a new project following the example of the first one to discuss document production and arbitration, with aims to also developing a guide to help the practice here in Brazil and other countries of Latin America. Now, quickly addressing Brazil and other countries in Latin America as to developments in 2025. Coming first to Brazil, we had in January 2025 the host country agreement between Brazil and the Permanent Court of Arbitration coming into force. The PCA is set to have an office here in my hometown, Rio de Janeiro. Most likely this year or the next, they will be opening the offices in a beautiful historical home in Botafogo, here in Rio de Janeiro. We also had in 2025 the issuance of a new law on private insurances here in Brazil. And what's most impactful for arbitration, that it provides that specifically the state that arbitration may be used on insurance contracts, but when the insurance regards matters related to Brazil, the proceedings must be seated in Brazil and governed by Brazilian law. Other than that, we had 2 major institutions here from Brazil, the CAMSI CBC and the CBMA, issuing new rules this year. Kansas CBC issue rules on November 2025, now establishing that challenges of arbitrators will be decided by a permanent challenge committee composed of 20 professionals that will decide in a collegiate manner, aiming at reducing the time spent deciding challenges of arbitrators. As to CBMA, it overhauled its rules and now made the provisions regarding expedited proceedings and emergency arbitrator proceedings into one single set of rules, and also allowed, I believe that's the first time in Brazil that one institution done that, it issued new rules regarding the issuing awards by consent regarding a settlement reached prior to arbitral proceedings starting. Moving on very quickly to some other countries here in Latin America. In Argentina, we have a bill under analysis aimed at extending to its international commercial arbitration law, also to interprovincial disputes. Nowadays, Argentina has a dualist system where international arbitration and domestic arbitration are dealt by separate set of rules, and they are aiming now at least for interprovincial disputes to submit it to the same statute as international arbitration. Colombia saw the enactment of Law 2540, which introduced the possibility of institutional arbitration for debt collection and enforcement proceedings, which traditionally was only handled by state courts. And this new statute gives arbitrators some enforcement-like powers, including ordering and managing precautionary measures like seizures and auctions. Costa Rica, on the other hand, had an overhaul of its arbitration law through Law 8937 that came into effect into April 2025, and moved Costa Rica from a dualist to a unified arbitration regime governing both domestic and international proceedings. It closely follows the UNCITRAL model law, and it also specifically dealt with the issues of non-signatories, of pre-arbitral tribunals for provisional measures, virtual hearing, and judicial enforcement. Following that, the Centro Internacional de Conciliação e Arbitragem from Costa Rica also has updated its rules to follow the new set of the new law. I only comment 3 more countries that had significant developments. The first one is Ecuador, who also saw a host country agreement with the PCA come into force in April 2025. Panama also had a development regarding investment arbitration when it signed the United Nations Convention on Transparency in Treaty-Based Investment State Arbitration in January 2025. And last but not least, Peru had a new public procurement law entering into force with new requirements for those acting as arbitrators and for arbitration institutions, which are quite relevant because all public procurement in Peru is dealt through arbitration. It also had a new public-private partnership law, and also some development of the practice regarding public-private partnerships. Peru is slowly but surely changing from the use of the ICSID rules for these kinds of contracts to beginning using more the ICC rules in the newer contracts that are coming. And finally, we had 2 institutions there also updating its rules to the new regarding the new laws. That is the Centro de Arbitragem de la Câmara de Comercio de Lima, Centro de Análise e Resolução de Conflitos de la Pontificia Universidade Católica del Peru. So this is a quick overview. Latin America is a very big region, but I'm sure at least I could bring to you some of the most relevant developments regarding this last year.
Absolutely. Thanks so much for that, Bernard. Very sort of comprehensive coverage of the continent, but as you said, we hopefully will have more time to get into some of those topics in more depth in the second round. And lastly, I'd like to turn to Anna to give us an update on Mexico and Central America.
Thank you, Aruna, and well, thank you for all the ones who are online. Well, first of all, I will be as Aruna just mentioned, I will focus on Mexico and some details about Central America. And well, regarding an overview of the Ciarb North American branch, I'd like to tell you that our chair, Cecilia Flores, and our co-chair, René Deliux, together with the Atlanta International Arbitration Society, are preparing the North American branch annual retreat, which will take place in Atlanta from May 28 to May 30, 2026. So all the ones who are interested from the North American branch or other branches are more than welcome to join. So please stay tuned for the registration opening, or well, also feel free to drop me a line directly to share additional information. Well, in general, in the region, there have been some developments by arbitral institutions, and more than developments, there have been interesting collaborations. Jus Mundi has been really active with the main arbitral institutions, and they have created different collaborations, for instance, with the AAA ICDR. They are providing access to the AAA ICDR Dispute Resolution Journal. Also, with the ICC, they provide access, Jus Mundi ICC provide access to the ICC Dispute Resolution Bulletin. And with JAMS and Jus Mundi, they have created another collaboration focused on joint education and research initiatives. So these are tools that are available to all the ADR community, and I highly suggest you to check it out if you are interested in researching or just being up to date with the different developments promoted by the institutions. And something that's important in the region in general, and not only in the North America and Central America region, it's like for the world, is that the ICC rules of arbitration have been under review, and are expected to enter into force in June 2026. So as a leading, as the leader in international arbitration, well, let's see the changes that will be implemented and whether other institutions will follow the ICC steps. Well, with all this AI trend that it's observed by everyone and we all use it, some more, some less, some others reject it, but we have to adapt. Well, as we all know, and if we don't, well, if you don't, I'm happy to share that the Chartered Institute of Arbitrators has launched the guideline on the use of AI in arbitration. And this is a really comprehensive guide that it's really useful for all kind of users. I mean, for arbitrators, for counsel, and all the parties that might be interested. It outlines in general the benefits and risks of the use of AI. It sets out general recommendations, the use of AI by the parties and by the arbitrators. So it includes a template agreement on the use of AI in arbitration, and also includes a template procedural order on the use of AI in arbitration. Also, particularly in the United States, well, as Anne already mentioned, AAA ICDR has been really active with the AI arbitrator tool, and they have another couple of tools, the AAA chat book, case prep, and presentation AI, and the guidance on arbitrators' use of AI tools. So for arbitrators, particularly if you are a young arbitrator, these might be highly educative tools to get more familiar on how to draft an award, on how to take care of the proceeding. Even if you belong to a different jurisdiction, is a wonderful guide. So let's take advantage of these AI tools to make our job more interesting. And also, JAMS has developed an artificial intelligence disputes clause and rules, which is available on their website, and it's open to the general public. And in Mexico and Latin America, like there's not, I mean, we are following these trends, but the institutions have not really developed softwares or AI tools on their own. And that's also why these collaborations with JustMundi are really valuable. In Mexico, there are mainly two arbitral institutions. One is called Canaco, which is the Chamber of Commerce of Mexico City, which works throughout the whole Mexican territory. And they began 2026, boosting new generation of arbitrators. And they began with a course for new arbitrators. And the other center is called Centro de Arbitraje de México, and they also began 2026 with their annual academic competition that attracts talent from Spanish-speaking countries. So, academic competitions are running all around the year, and just as Bernard mentioned, well, there is the Bismuth, and many of us are interested in these competitions. Well, regarding investment arbitration, I will make reference a little bit later to an ICSID decision that will make a difference for other pending cases managed by ICSID in North America and Central America, particularly to those disputes relating to the NAFTA and the USMCA treaty. Because, well, we are in a very changing world. Like the current environment is really interesting for all of us, and many of the decisions that are ruling and changing the world, come from the United States. So let's see how things develop for all of us. And for the ADR universe. And I want to deep very much right now, but I just like to provide an integral idea of the environment of three phenomena that are currently changing the ADR universe in the North American region. The first one is the implementation of tariffs by the US administration that has triggered trade-related disputes, and not only trade disputes, like many other disputes surrounding these changes of tariffs. The second phenomena is the review of the USMCA that will take place in July of this year. And the third one is the judicial reform that has taken place in Mexico. Why is this important for international arbitration or international disputes? Well, because this reform affects the perception of a neutral and a predictable judiciary. And consequently, well, the interaction of these three phenomena or these three events, meaning the implementation of the tariffs, the review of the USMCA, and the judicial reform in Mexico, this interaction has an impact on the implementation of new strategies by the parties and the attorneys involved in a dispute, particularly in cross-border disputes. These strategies might imply abandoning local national courts and resorting to ADR methods. Resorting to ADR methods might mean redrafting new dispute resolution clauses, including escalation clauses referring to mediation and conciliation before ending up in an arbitration proceeding. And for instance, in Mexico, mediation and conciliation are not as common as arbitration. So this gives room, well, this reform gives room to use or to resort to mediation and conciliation. And it has been confirmed by the arbitration centers in Mexico that due to the lack of confidence in the new judiciary, attorneys, in-house counsel, business people, investors, and users in general are approaching to the arbitration centers to ask when and how to insert an ADR clause in their clients' contracts. And this may translate in the coming years into an increase in the use of ADR methods to settle disputes, including mediation and commercial and even investment arbitration. Another important consequence of this reform and the perception of the public in general or of the users is that it might have, well, this lack of confidence in the new judiciary may impact the selection of a different seat of arbitration, meaning that this can cause abandoning Mexico as the place of arbitration and favoring other arbitration hubs such as New York, Houston, Miami, London, Geneva, or the seat that the parties prefer. However, I must say that not all the new judges lack professional experience. Some of them were previously members of the judiciary in lower positions, and also, despite the fact that some of the newly elected judges lack experience, most of the staff who remained in the judiciary have been working there for many years, maybe even for decades, and they know how the applicable laws work and how to manage cases in accordance to the applicable laws. So, and also there's something very important that according to the ICC and to the experience in general, Mexico, it's a good seat of arbitration despite this reform. Why? Because, well, it has adopted the UNCITRAL rules. Human rights in general are respected. There are really experienced practitioners in the judiciary and as attorneys. And the judiciary in general has favors arbitration in Mexico. So also, like, there's an important trend to respect the right to due process and the admissibility and weight of the evidence. So even if there's a general feeling of uncertainty, not everything is lost. Like the Mexican judiciary, it's also, and Mexico can be a good place or seat for arbitration. So, well, as members of the ADR community, like, it is important to promote an adequate analysis of the needs of every case or every contract in order to resort to an adequate method to settle commercial or investment disputes.
Thank you, Anna. Thanks for that update. I think some of those topics we'll probably do a deeper dive into during Q&A as well as a roundtable segment. Now, I'd like to start off on part 2 of the webinar, which is a roundtable discussion. We would want to sort of cover a couple of topics here, and if you have time, we'll touch on others. The key topics that we want to look at are key arbitral decisions or court decisions coming out of your jurisdictions. And I think some of the speakers touched on this previously, but a deeper dive into the geopolitical trends and their impact on ADR, as well as everyone's favorite topic at the moment and the most sort of engaging topic for practitioners is the use of technology and AI. And if we do have time left, we'll also sort of get into more developments on mediation, etc. So I would at this point ask our audience to come in with their questions. Feel free to sort of drop your questions in the chat box or the Q&A function, and we will pick those up as they come in. So moving on to the first of those topics that I mentioned, we'd like to hear from the speakers about the key arbitral decisions or awards that are emerging or that have emerged in 2025 from their respective jurisdictions. To start off, Bernard, can I turn to you, please?
Thank you, Aruna. I'll just comment on 2 decisions that better establish the boundaries between the arbitration and the state courts here in Brazil. But prior to that, I'd just like to mention that our superior court here in Brazil, that is the court that decides on issues of enforcement of foreign arbitral awards here in Brazil, maintains a very pro-arbitration stance for the last 15 to 20 years. It has been so. And it's quite rare for you to see decisions being denied enforcement here in Brazil. In the last 5 years, I believe there was only one and only a partial denial of enforcement regarding an anti-suit injunction that was contained on together with an arbitral award, and only that part was denied enforcement of that. That was not on 2025, just to comment on this trend. The 2 decisions I'd like to comment, both from the Superior Court of Justice here in Brazil. The first one from April 2025 relates to judicial reorganization and bankruptcy. In its decision, the Superior Court once again decided that the parties that are subject to judicial reorganization or bankruptcy proceedings are still bound by previously agreed arbitration clauses. And should a dispute come in while judicial reorganization and bankruptcy proceedings are ongoing, it will have to be submitted to arbitration prior to the credit that arrives from it being entered into the bankruptcy or judicial reorganization proceedings. And it also clarified the matter of offsets in arbitration when it comes to bankruptcy, stating that offsets are considered to be disposition of the credits of the company. Hence, offsets are not possible in arbitration when the company involved is undergoing a judicial reorganization or bankruptcy proceedings. This has to be done at a later stage, if possible, at the bankruptcy proceedings. The second decision from August 2025 relate to enforceable instruments here in Brazil, which we call here in Brazil títulos executivos. The Superior Court of Justice clarified that títulos executivos, if they are if they are for a specific and set amount, may be brought directly to the state court for execution. However, if the opposing party have some opposition that relates to the merits of the title, if it disputes the legitimacy or the amount of the title, then this must be brought to arbitration if the parties had agreed on an arbitration agreement. In this case, the court proceedings will have to be stayed, waiting for the decision of on the amount of the title or on the possibility of enforcement of the title, and then we'll come back to the state courts to continue the execution of the amount proper. This would be the two decisions that have a more meaningful impact in arbitration in general here in Brazil that I'd like to comment.
Thank you. Thanks for that, Bernard. Can I now turn to Anne to highlight some of the decisions coming out of the US?
Yeah, I'd be happy to do so. Of course, I already spoke about two cases that I think are fairly significant. I might add that 2025 was the 100th anniversary of the Federal Arbitration Act. And I'm happy to say that arbitration is alive and well in the United States, despite a few outliers every once in a while. I don't have any other cases per se. The Supreme Court has not really come out with anything in 2025, but I do want to talk about a trend that I think is important. And this is a trend. And when I say a trend, it's that we're seeing more and more of the courts adopt this theory. In First Options versus Kaplan, which was a 1995 decision by the United States Supreme Court, the Supreme Court grappled with the question of who decides if a particular claim is arbitral or not. And they had language in that award that said, that opinion that said that unless there was a clear delegation to the arbitrators to decide that issue, that the issue would be decided by the courts. They referred to it as a gateway issue. So what happened in the United States was the question of competence. Competence was being determined by the courts as opposed to being determined by the arbitrators. The Supreme Court hinted in the Shine case a couple of years ago that if parties had in fact put in their arbitration clause an arbitral institution to resolve the case, and in fact if those rules stated that the arbitrators had the ability to determine their own jurisdiction, that could be considered a delegation. And in fact, most of the cases now that are addressing this issue are finding that if the parties have selected in their arbitration clause a particular institution, then that institution has in its rules that they have the competence, the arbitrators, the competence to determine their own jurisdiction, then that constitutes a delegation. And the arbitrators will make that decision. Now, this has one interesting impact to it that changes things within the United States, and that is under the options case, competence, with the court making the decision, then any review of that would not be subject to the bases for setting aside under the New York Convention. If, in fact, the arbitrators have the power, if it's been delegated to them, then the review is going to be under the New York Convention, which is going to be much narrower as to what can occur. So this is somewhat groundbreaking in the US, and there seems to be a groundswell of courts that are agreeing with this particular position, which puts the United States back in line with the rest of the world on this question of who decides.
Thank you, and it's a very interesting development indeed. I'd like to now turn to Anna again to see if there are any significant cases coming out of Mexico and Central America.
Thank you, Aruna. Well, I will focus on some ICSID decisions covering the region, particularly of North America, because there is this interaction between Mexico, the United States, and Canada. But let's begin I will go down for I will go to the south before, and we'll begin with a very good news regarding Honduras. On just a couple of days ago, meaning on January 27, 2026, their new elected president of Honduras, Nasri Asfura, announced his intention to rejoin ICSID following a change of government. His new administration aims to restore legal certainty and improve investor confidence, reaffirming Honduras' willingness to submit investment disputes to a well-established and widely used international arbitration framework. And well, naturally, this will improve investments in the region because more capital will return or will enter into Honduras. And there is a good ICSID case that it was filed in 2023, and it is Access Business Group LLC, an American company, against the United Mexican States. And this ICSID case is a milestone arbitration based on the USMCA treaty, but well, in reality, this award marks the sunset of the NAFTA disputes. This kind of investment arbitration disputes, as the tribunal concluded that it lacked jurisdiction over the claim, highlighting the relevance of temporal treaty rules, although a dissenting opinion was issued. The importance of these temporal treaty application rules is underscored in this case, and may be of paramount importance for 8 other investment arbitration cases under the USMCA currently pending before ICSID. This means that, this treaty was called initially the NAFTA in English, and it was renewed and reformed or amended, and even its name was changed for the USMCA treaty. And the disputes that were filed under the NAFTA scheme, are getting to their end. So let's see how this case, the Access Business Group LLC, marks a difference for the rest of the cases that will be decided in a similar way. And also, ICSID, as the hub for investment arbitration cases, the Central American countries had an interesting activity during 2025. 5 ICSID cases were filed against Mexico. Next was Panama with 4 cases, 2 against Costa Rica and 1 against Honduras. There were none cases filed against Nicaragua and Guatemala. And that was basically the activity of investment arbitrations in the region.
Thanks a lot, Anna. Can I now turn to Patricia for an update from Europe?
Yes, I will give you some case law from Italy. In Italy, a landmark 2025 Supreme Court decision. It is very recent, April 2025, confirmed the statutory arbitration clauses providing for a foreign seat are valid so long as the arbitrators are appointed by an independent third party and the arrangement complies with international recognition standards such as the New York Convention. So this pronouncement underscores Italy's commitment to enforce international arbitration agreements, even where a foreign seat is chosen by the parties. Another notable ruling, Italian ruling from the Court of Appeal of Venice, 10 June 2025, clarified that recognition of a foreign award may not be refused simply because an annulment proceeding is pending in the award's country of region, as long as that proceeding does not have an automatic suspensive effect under foreign law. So this reflects a nuanced approach to balancing enforcement and judicial oversight. Then I have some cases also from France. In France, 2025 case law highlights the limits of judicial review and deference to arbitral decision making. So a case decided by the French Court of Cassation, also May 2025, involved the annulment of a decision of the Paris Court of Appeal that had set aside an international arbitral award on jurisdictional grounds. The French Court of Cassation overruled the appellate court because it had impermissibly reviewed the merits of the dispute instead of confining itself to statutory grounds for annulment. So this confirms France's tradition of protecting the autonomy and finality of arbitral awards and the limited scope of judicial control in annulment proceedings. And additionally, the Paris Court of Appeal has reaffirmed the principle that parties cannot introduce entirely new jurisdictional arguments at the annulment stage that were not raised before the arbitral tribunal, emphasizing the importance of procedural loyalty and respecting the tribunal's competence. So these rulings demonstrate that French judiciary preference is for minimal intrusions into the arbitral process, reflecting a strong arbitration-friendly jurisprudential ethos. Then another case from Spain. In Spain, a notable 2025 judgment from the Court of First Instance number 1 of Torrevieja, also June 2025, so very recent, represents an important development in the enforcement of non-institutional or irregular arbitration awards. In that case, a Spanish court upheld the enforceability of an Italian so-called arbitrato irrituale award is a form of non-institutional arbitration by treating it as a contractual determination subject to ordinary enforcement. And this was groundbreaking because such award traditionally could not be enforced under the New York Convention formal regime. So by framing the award as binding contractual performance, the Spanish court facilitated cross-border enforcement of non-traditional arbitration outcomes, illustrating a pragmatic approach that aligns legal form with substantive party expectations. And well, finally, but not least, from Poland, from the East, Poland's arbitration regulatory reforms in 2025 illustrate a broader trend toward procedural modernization and efficiency. So the updated rules of the Court of Arbitration at the Polish Chamber of Commerce, effective from 2025, introduce innovations such as service of documents by email, early determination procedures, mandatory time limits for award issuance, and simplified procedures for lower value cases. So these changes mirror the preferences expressed in 2025, and I hope that this is an overview of the most important cases in Europe. Thank you.
Thanks, Patricia. Very, very interesting developments across those jurisdictions as well. Now we'll turn to sort of the second topic for discussion, which is on technology and AI. Most of our speakers did touch on this topic during the introductory pieces, but we'd like to sort of hear from them what their experience is on the ground, as well as any decisions or trends that they can sort of speak on with regard to what's happening on AI in their jurisdictions. Before I turn to the speakers, I think there's a question from a member of our audience, and I suspect this might be one for you regarding the AAA AI arbitration rules. The question is, for the AI-assisted arbitration award, noting that there is a human intervention at the back end, is there not an issue of the decision being skewed in favor of the party that feeds the AI tool with more data than the other? Or is there a cap limit on data that gets fed into it by parties for a more balanced result?
Well, that's a great question. And there is no limit to my knowledge. if you think about this and we take it out of the AI situation and we have a human arbitrator solely do it, just because there is more data on one side than the other does not mean that the arbitrator is going to be biased in favor of the party that put in more data. So one has to presume that the same would be true for an IA arbitrator. That being said, there are certain guardrails within the rules. One of the guardrails I've already spoken about, and that is that the IA arbitrator creates an award, which then has to be reviewed and blessed by the human arbitrator. And the award then becomes the award of the human arbitrator. But there is yet another guardrail in that, and that actually can be found in, I saw your question, so I pulled up the rules so I could tell you exactly where. It's R6 E. After the arbitrator, and by arbitrator, I'm talking about the AI arbitrator, has confirmed each submission from the claimant and the respondent. And oh, by the way, if the respondent doesn't put anything in, the case still goes forward, just as it would if you were with a human arbitrator. So the AI arbitrator confirms each submission. The parties will have an opportunity in the parties' feedback stage to review and comment on the AI arbitrator's summaries of their claims, evidence, exhibits, and legal authorities. So that is yet another guardrail to help prevent any sort of bias within the IA arbitrator's decision process. But in terms of a limit on data, no. But we also must remember that this is very limited in that it is related to two-party, document-only arbitrations. And you can put in legal authorities, witness statements, and the documents that support the position.
Thank you, Anne. Thanks for that. I think to sort of kick off this segment, I will remain with you to provide us with more insights on the use of AI in your jurisdiction.
I'm sorry, who did you direct that to, Aruna?
I'll stay with you on this one, Anne, for sort of an update
Oh, okay.
on
I'm
the
sorry.
use of AI.
Oh, certainly.
Yeah.
You know, a couple of things. The AAA has contracted with ClearBrief to provide AI as a tool for the arbitrators to use. It is to be used, for instance, in the development of the timetable and in histories and the like. And if you file something with the AAA, you also are able, as an arbitrator, to see an AI summary of that document that has been filed, which can sometimes be extremely helpful to the arbitrators. Of course, the big question is, and this is a closed AI system, the big question is it closed or open? And when you move into open, there's a problem with confidentiality, which is a big issue. So the closed systems are only as good as the input that they have at the moment. And so it's still somewhat in an infancy stage. I would also state that while I haven't seen anything relating to arbitrations, there have been numerous cases in the United States now involving hallucinations, where lawyers have filed pleadings that have cases cited that do not exist, and courts have imposed sanctions in some instances. And there is even one case in the United States in which the opinion of the judge had hallucinations in it. So it's something that definitely has to be guarded against. And I think it might be appropriate here to talk about what some of the universities are doing. Because obviously students wish to use AI as well. I'm an adjunct at the University of Houston, and they leave it up to the instructors themselves as to whether or not they're going to permit AI or not. For myself, I do permit them to utilize AI for purposes of research, but they have to certify that the drafting is their own drafting. And a false certification would be an honor code violation at the university, which would cause them to be expelled from the university. But AI is here. If you think about it, Westlaw and Lexis are a type of AI. It's here. It's just being taken to the next level, and we need to learn how to harness it to the best of our abilities.
Thank you, Anne. And I should also add that I think the approach you mentioned that's been followed by academics, the Ciarb journal recently introduced its AI policy for submissions to the journal, and it broadly follows what you just outlined in permitting certain users, but also leaving responsibility and ultimate accountability with the authors to certify what their uses of AI were. Moving on to developments in Europe on technology and AI, Patricia, could you provide us with some insights, please?
Well, in Europe, AI is being used primarily as an assistive tool, not as a decision maker. Most common uses I see in practice are document review and prioritization, cross-border legal research, or building chronologies and testing arguments. But at the moment, there is no appetite among tribunals or institutions to delegating reasoning or decision making to AI. The AI is supporting arbitrators and not replacing them at the moment, we can say. For now. And then what about the Ciarb guidelines? They were already mentioned on the use of AI in arbitration. They are increasingly referenced as practical benchmark, especially useful for disclosure of AI use, human oversight and confidentiality and data protection. And the broader EU regulatory culture, including the EU AI Act, strongly influences the thinking like risk-based approach, explainability, accountability, and even if not arbitration specific, this mindset shapes expectations. So about the court and the due process, European courts remain extremely sensitive to equality of arms, transparency, and proper reasoning of awards, and any undisclosed AI used that affects evidence or submissions could become fertile ground for challenge. So the tribunals are generally pragmatic. Some procedural orders now as parties to confirm whether AI is used and focus on protecting confidential and privileged data. And the research of drafting support, but with always with the responsibility by the humans. So this is the approach that we have in Europe. And as already mentioned, also there is a collaboration with Usemondi, especially for the research, the analytics, and the efficiency. So AI, of course, is welcome, but is at the moment still used as a tool. So there is a process of trust that is growing, but we need more time, of course.
Thanks, Patricia. I think the EU AI Act is going to be sort of a significant player in this space, and sort of I think the decisions coming out of the Act and the interpretation of the Act will be very important for many jurisdictions going forward. Can I now turn to Bernard to sort of give us an update on the use of AI and technology in Latin America?
As to relevant developments in 2025, I would like to point to developments both relating to Kansas CBC. The first one was that in 2025, Kansas CBC issued its Administrative Guidance 7/2025, on which it dealt specifically with the use of AI in arbitration. First, it recognized the potential gains in efficiency and also the risks associated with the use of AI tools. It clarified that it currently does not use AI tools in the administering of the proceedings, and that if it begins doing so, it will issue another guidance relating to how it's being used. Second, it provided that all stakeholders should be held responsible as to the use of AI in arbitration. That is both the arbitrators, their counsels, the parties, particularly regarding ethical and legal duties. Confidentiality is one of the main concerns on this regard, as Anne already pointed out before. And third, it specifically encouraged our participants to discuss the use of AI when preparing for proceedings. And from my practice here, I see that in its terms of reference, it is common that parties are now discussing whether or not AI is being used, how it's being used in arbitral proceedings. From speaking with colleagues from big law firms here in Brazil, it's quite common for all of them to have some kind of AI assistance, particularly for managing document production and selecting documents for use in arbitral proceedings. The second development, and this borrows a little bit from what Patricia also mentioned, is the partnership with Jusmundi. Jusmundi is currently partnered with several of Brazilian arbitral institutions and also some others from Latin America as a whole. And in 2025, it uses Juice AI, it's AI, closed AI too, to anonymize and select extracts from arbitral boards from Kansas CBC in order to release it to the public. Of course, there is still a stage of human review at the end of the work. But speaking both with Kansas CBC and Jusmundi, both confirmed that at this first stage they used a mix of some cases being summarized and anonymized by humans and others by AI, and they concluded that the AI usually gets better results in this topic than than humans. So going forward, they most likely will issue new collections of awards using mainly AI to produce the extracts and anonymize them, only with some human review at the end to see if anything got past the AI. Finally, I do know that Ken Santiago is in the last steps of developing recommendations on the use of AI that is promised to be released on the beginning of 2026, I believe, in the first semester. So those would be the main developments in arbitration. As did Anne mention, here in Brazil, we also do have the same situation. We have at least 6 decisions from 2026 where counsel for the state courts, no, I do not know anyone in arbitration, but where counsel were reprimanded and applies sanctions due to the improper use of AI and AI hallucination. So it's a problem that more and more arbitral practitioners, counsel in general, are becoming aware of and preparing for a proper use of AI in the future.
Thank you, Bernard. Thanks for that. And I'd like to turn to Anna to provide an update from Mexico and Central America.
Thank you, Aruna. Yes, well, in general, there have not been many decisions issued in this regard in the Mexican territory, and I'd like to focus on the use of, on insights on the use of AI by lawyers and the obligations or the duties of the arbitrators. The use of AI by lawyers and by law firms, it depends on, of course, on internal policies, but following the guidelines of different institutions, for instance, as the Chartered Institute arbitration guidelines and the internal policies of a law firm, first they have to verify that the software or the platform keeps information really safe and confidential. And after this, we have to obtain the client's agreement and to inform them. Because that's the duty to tell them, like, would you like us to use AI in your case or not, and then the client decides. And of course, they will raise the necessary questions to make sure that their case will be handled in an appropriate way. And of course, here it's also a budget issue, because as Anne was mentioning in the construction paper, well, in the construction cases that can be processed by the artificial intelligence software of the ICDR without human, well, that can be processed by AI, and only after the final stages the human will intervene. Well, that saves money, but some clients will prefer to have, well, human intervention only, because also, like, that's why they are looking for a professional or a professional service. So it really depends. And well, there was this scandal of Deloitte Australia, like, what a reputable firm. But they delivered a report that included hallucinations from AI. And as Anne just mentioned, there have been many cases that have been reported with these hallucinations. So that's also why first obtaining the client's agreement on the use of AI is basic. And it's also a duty of the attorneys to verify that the software has not hallucinated, and to confirm that the sources and the information is reliable. So in a way, it saves time, but in another way, it requires more time investment, because in an arbitration, like, one of the parties files some evidence, but if they summarized it with AI and there's an hallucination or a mistake, the opposing counsel will invest more time in checking that evidence, how it was processed. And also for the arbitrator, it's very risky in terms, I mean, as an arbitrator, you have to verify that all the information is reliable. And how are you supposed, as an arbitrator, to verify that all the information that has been provided is precise and is reliable? Because you don't know which tool and how precise is the AI that they have in that law firm, or the third-party provider that they are using. So from my perspective, I think that we are still at the very beginning on the use of AI. But I don't know if there's time to listen to others' opinions on this from our colleagues, or from Anne, from Aruna, from Bernard, from Patricia, or from other of the attendees. I'd like to know if you really trust AI that much to file a case and to issue a decision as an arbitrator.
That's a very interesting question, Anna, and sort of speakers are free to weigh in on that, whether, weighing up the costs and benefits, whether in your particular practices or regions, whether it's sort of used in a widespread way. Yeah, happy to hear everyone's thoughts on that. But I'll also sort of pose another question that's coming through the Q&A, which is tech related in relation to electronic awards. And I'm happy for any of the speakers to pick this up and respond. The question is, please share your thoughts about developments in the use of electronic or digital awards. I suppose if you can touch on whether those are permitted, or whether there are decisions enforcing e-awards in your jurisdictions, that might be helpful if there are any developments. Is there any sort of traction on
Well,
e-awards in your
I'm
jurisdiction?
not quite certain what they mean by electronic awards. I will say that, for instance, the ICC rules permit, with the parties' agreement, for them to receive the awards electronically. And that has occurred in a number of cases in which I've been involved in. if that is what is meant by electronic awards, then of course that is happening. And in that instance, my award has been sent to the ICC electronically as well. But then the ICC, of course, would then just endorse it if it needed to, certify it if they needed to for purposes of enforcement. So I don't know if that's actually answers the question that's been posed, but that has been my experience.
Thank you, Anne. Unless the other speakers had something to say on that. Yeah. Go ahead, Ben.
No, I heard some development, not from last year actually, but from a few years before regarding electronic awards, meaning awards that were self-enforceable through the use of blockchain. I don't know if that what's being mentioned here. If that is the case, to be quite frank, I heard about that, saw some small business excitement over that, but to be quite frank, I did not see it gain traction, at least in the jurisdictions that they usually act. But I'm not sure if that's what's being asked for from us.
Thank you. So mindful that we are sort of running out of time and we have a topic to cover, we'll sort of move quickly to the last topic of today's discussion, which is on geopolitical shifts, and to learn in particular how sanctions, tariffs, and other sort of geopolitical trends are impacting the use of ADR. And mindful again that we have around 10 minutes to go through this section, I'd like to invite Patricia to share your thoughts.
Well, I would like to share just some words about this topic. The sanctions have had a real impact and practical impact on arbitration in Europe, and so we see this clearly in the choice of seat, especially in Europe. Parties are gravitating towards seats perceived as stable and predictable, and especially to Switzerland, to Paris, London, which remain popular, and other seats in Europe. But this is one of the perception that we have. And also the increase in disputes involving force majeure, impossibility or illegality of performance, payment blockages due to sanction compliance. So these issues arise both in commercial arbitration and investment contexts. And well, what is the role of courts in this scenario? European courts are increasingly asked to decide whether arbitration agreements remain enforceable under sanctions, whether payments or enforcement would breach sanction regimes. And we also see more complexity around enforcement of awards, anti-suit and anti-arbitration issues linked to sanctions, and also the consequences in the trade restrictions and tariffs that are influencing price adjustment disputes, long-term supply and distribution contracts, and this especially is visible in manufacturing, energy, and commodities. So this is the geopolitical situation that we have. Well, we have moved, of course, from the background into the center of our arbitral strategy, but these are the main issues that we have to face in this context.
Thank you, Patricia. Anne, can I turn to you on that topic?
Well, first of all, I agree with everything that Patricia has said. I think that's a universal issue that we are addressing now, but I'd like to take it from a little bit different point of view, and that is the point of view of the arbitrator. Yeah. And from the point of view of the arbitrator, it is clearly sanctions are having an impact on the cases that the arbitrator is able to take. For example, if you are from a country that is sanctioned Russia, it is, at least in the United States, you should not be taking a arbitration in which there is a Russian party, or in many instances, a Russian parent of that particular party. This is for the trade lawyers to sort out. I don't pretend to be a trade lawyer, but it is very, very complex as determining whether or not the party before you falls within the sanction aspects of it. Then you have, in addition to that, let us assume that the arbitrator has obtained a license to be able to sit as an arbitrator in that particular case. Well, we also need to have an arbitral institution that has a license that allows it to take the payment from that party. But then we have a lacuna, and that lacuna or gap is the banks and whether or not the banks themselves will accept the payment from the institution to the arbitrator, both of whom have obtained licenses. And that can be the logjam that exists as well in terms of being able to pay. So you have all of those problems. Then in addition to that, you do have some jurisdictions that are now touting themselves as the jurisdiction to go to, such as the Hong Kong holds itself out as being a seat for sanctioned parties in arbitration. And so you need to think about that as well. So you're impacting the arbitrator, you're impacting the seat, you're impacting the institution, you're impacting payment, all of those things together. Then that, of course, raises the specter of force majeure in a party's contracts themselves. And can you maintain that because of the imposition of sanctions, that in turn constitutes a force majeure problem? And then we have the last problem, and that is if you were able to get past all of these problems, Russia, if you're from the United States, is going to take the position that merely because you're from the United States, you're biased against the United States and against Russia and file an objection, have been successful on that. And then you also have the instance in which there has been at least one arbitrator who simply because they reposted something on LinkedIn that was in favor of the Ukraine, they were disqualified. So the geopolitical hangs over everything at the moment, from the beginning of the case to the end of the case for the parties to the claims. Every aspect of it is touched by it.
Thank you, Anna. It really sounds like a very sort of complex environment to navigate for an arbitrator. I would like to now turn to Anna to sort of provide insights on this topic.
Thank you, Aruna. Well, I have focused more on the geopolitical shifts that are impacting ADR in general in this time in Mexico, and not only Mexico, the North American region, according to the USMCA treaty, as was mentioned before. Well, many disputes under the initial treaty that was called the NAFTA are getting to the end of the same conditions, and after the NAFTA turned into the USMCA, there were way more restrictions on how to deal with these kind of investment disputes. And that's why this case we talked about, the Access Business Group LLC against the United Mexican States, that was filed on 2023, but their final award was issued on November 2025. That's why this is important, and how it is important to consider the temporal treaty application of the rules, because these kind of disputes are getting to their end. And also how there are these geopolitical shifts affecting ADR regarding the Mexican territory with the judicial reform. I haven't mentioned it yet, but for those who don't know, in 2024, there were some elections to vote for the new judges and magistrates that were elected by the people, the Mexican people. So this is a really an important shift in the way that the judiciary is working, because there's this judicial career that was constructed before. Well, it's has faded, um, but it is important to take into account that many of the officers working in the judiciary had not left. So it doesn't mean that the head of a court, if it's a new member, it doesn't mean that the rest of the staff it's new, because most of the staff stayed except for the heads, and most of the times real work is done by the rest of the staff, and the head, well, asks, signs, and uh, let's say that the main responsibility stays with the rest of the staff. But because this might cause uncertainty to the users, particularly to foreign users of cross-border contracts, that's why it's important to, well, they prefer to rely on ADR in arbitration, mediation, and different methods to settle their disputes. So this is a good opportunity to see how mediation and conciliation and arbitration, its use increases in the Mexican contractual relationships.
Thanks, Anna. Definitely something to watch out for in 2026 then. Finally, I'd like to turn to Bernard to sort of weigh in on this topic of geopolitics.
Thank you, Aruna. I promise I'll be short, mainly because as far as I'm aware, we in Brazil have not seen many impacts, neither from sanctions nor from tariffs. I even ran around asking some colleagues regarding this issue, and the only 2 points that they brought to me were, first, that the sanctions regarding Russian parties have led some Russian companies to seek Brazil as a possible seat for arbitration, and arbitral practitioners as potential arbitrators in their disputes, mostly because Brazil usually does not follow sanctions on Russia. And some of them also reported to me as to the tariffs that some companies have consulted them on possible impacts on their contracts, but at the end of the day, no dispute came from it. Either they agreed on new terms with their commercial partners, or decided to go ahead and wait a little bit to see what the tariffs would become, and they do change quite often. In Latin America, other than the fact as Anna previously mentioned, that Honduras, after its newly elected president came into office, most likely will rejoin ICSID. We do have some scholars, some practitioners seeing that maybe awards against Venezuela may become easier to collect with the new government there, but honestly, it's a little bit too soon to truly know what will happen in Venezuela in the next few months or years. So that would be my point regarding tariffs and geopolitical events.
Thank you. Thanks so much for that, Bernard. I see there was another question in the chat box, but I can see that you have addressed that with the audience directly. So I'm afraid that's all the time we have for today. I'd like to thank our wonderful speakers once again for sharing their time and expertise with us. And we're very grateful for their contributions. I'd like to also thank the audience for sort of staying patiently with us and engaging with the speakers throughout the webinar. For all updates and information on future Ciarb events, please visit our website or follow us on LinkedIn. Thank you very much.
Thank you.
Thank you,
Thank
Aruna.
you.
Thank you
Most
all.
enjoyable. Thank you.
And Patricia, thank you for sharing the date for the annual conference.
Yes, I invite you all. Krakow is a beautiful city, so please
Yes.
join us.
Thank